this video, we should put before you the third lecture in international law. The third lecture explain the influence of law of nature on the international law. Also discuss the theory of positivism. What are the theories as to law of nature and positivism? Discuss the Pacata Sunnt Servenda. Also explain the sanctions of observance of international law. This question had been repeated in CSS exams in 2002, 2015, 2017 and 2018. Intro of this lecture, the law of nature has influence on the international law and several theories of international law are based upon it. It is also said that the states submitted to the international law because their relations were regulated by the higher law, the law of nature, of which international law was but a part. On the other hand, positivists hold that the rules of international law are in final analysis of the same character as positive municipal law, i.e. that is state law. According to Angelotti, a protagonist of positivism, the binding force of international law can be traced back to a fundamental principle that agreements between states are to be respected. This principle is better known as Pacata Sunnt Servenda. The history of law of nature is traced back to the Greek. It is evident from crossroads of history that law of nature has extended influence on the international law. According to Grotius, the father of international law, who has reconstructed the semi-theological association of the law of nature and secularized it. His followers applied this theory and held that the ideal law is based on the nature of human beings. On the basis of this very conception, the theorists and writers were of the view that international law derived its binding force from the fact that it was mere application to a particular circumstances of the law of nature. In a very simple and easy words, states surrender to the law of nation, also called the international law, because their relations were conducted under the higher law, that is called the law of nature. Kelson is of the view that theory related to the law of nature remained dominant during the 17th and 18th century. This theory is also called idealistic theory. No doubt, this theory is not precise but is more subjective than objective. The critics have commented that the main defect of this theory is to aloofness from the realities of international intercourse, shown in the lack of emphasis on the actual practice followed by states in their mutual relations. On the other hand, according to positivists, the states will in international law has the full attributes of sovereignty and authority. They assume that the international law is composed of rules which are accepted by the state through process of voluntarily self-restriction. Angelotti, an Italian jurist of international law, has been the outstanding positivist. He also remained judge of Permanent Court of International Justice in 1930s. He was of the view that the binding force of international law is based on the fundamental principle that agreements between the states are to be bound and are to be honored, and this principle is known as Pacata Sunnt Servenda, which means the agreement should be honored. Angelotti had also advocated his theory and commented that, like the treaties, the customary rules of international law are also based on the implied consent of the states. There are also certain objections, and there is criticism on this theory, this school of thought, like the school that supported that the international law is based on law of nature. The critics said that the expression state is purely metaphorical and is used to define the fact that international law is binding on the states, but it does not shed light on the complete fact. They were of the view that state will is merely fecundly parallel, and the only will which operate is the will of the individual which govern the state of system of state. The second objection is this: in case of customary rules, at many instances it is not possible to find consent of states to the binding effect of the rule. The third one is particularly for American system. Uh, it is said that the government of the United States has on various occasions announced the principle that international law as a system is binding upon nations, not merely as something to which they may be but tacitly assumed to have agreed, but also fundamental condition of their admission to full and equal participation. And other is by Professor H. Smith in his celebrated writing Great Britain and the Law of Nation. He emphasized that international law is binding upon all civilized states as whole, irrespective of their individual consent. According to critics, it is also practically not possible, while invoking the particular rule of international law against particular state, to find out that the state has diplomatically consented for the law. At the end, the important part of lecture is sanctions of observance of international law. It means what things, sanctions which play great role in enforcement of international law. The first one is a collective sanction. In the cases of breach of international law, peace, threat to peace, or act of aggression by any state are to restore or maintain peace. The United Nations Security Council, pursuant to Chapter 7 of the United Nations Charter, may exercise the option of collective sanction. In the collective sanction, UN Security Council imposes on behalf of the United Nations collective sanctions against the state who has distorted the peace or broken the principles of international law. The second one is the exercise of paragraph 2 of Article 94 of United Nations Charter. In case of non-implementation of the verdict of International Court of Justice by any party to a case on the request of aggrieved party, UN Security Council may compel the defaulter state for the enforcement of international law. This third is self-restraint. By virtue of paragraph 4, Article 2 of UN Charter, all the members states are to refrain from the use of force or threat to use against another state or political independence and territorial integrity of state. Right of self-defense. Article 51 of UN Charter also provide a right of self-defense to a state against whom an attack has been made by another state or terrorist. Economic sanction. The economic sanction has also a great role regarding enforcement of international law and observance of the rules of international law. External pressure. External pressure is also one of the tools in international law for enforcement of its rules. Public opinion. Public opinion is a very important and have a great role in observance of principles of international law. Due to globalization, the public opinion has gained much importance. Therefore, it also plays a very effective role for enforcement of international law. Second, last one is the inquiry and probe commission. In different cases and at different occasions regarding violation of rules of international law, regarding breach of treaties, the inquiry and probe commissions are constituted to fix the defaulters, and the non-adherent has to face the muser. It is therefore established that international law has observance sanctions as well, and the principle of Pacata Sunnt Servenda is also the principle derived from common law, which means the agreement should be honored. Therefore, The international law has a complete mechanism regarding its observance, enforcement, and binding force. Thank you very much. And at the end, we again request you to please like our videos, uh, comment upon these, and also subscribe our channel. Thank you very much. May Allah bless you. Thank you, please.